Okay, Learning Plan 4, Part B. We ended off the last section talking about the elements of malpractice and that the plaintiff needs to prove their claim. The plaintiff needs to prove that there was a duty, that there's a breach, that the breach was foreseeable, and that there's an injury. That is all up to the plaintiff. And as long as you are acting within your scope of practice and using a reasonable line of action, you will probably be protected should you act as a good Samaritan. Let's talk a little bit in greater detail about the elements of malpractice. Proving that there's a duty. How would the plaintiff prove that there was a duty there? Well, first thing, they would go to the Nurse Practice Act, because the Nurse Practice Act sets guidelines for each state. They set the scope of practice for all nurses. Staying within your scope will help protect you. Have you ever seen a nurse that wrote their own orders? I have. I saw, when I worked in the ER, I saw a nurse, a patient came in, a little child, fever. Patient went and got some ibuprofen, liquid ibuprofen, and gave it to the child before the doctor even saw. Was she working within her scope? No. Was there any harm? No. There was a duty. There was a patient duty. There was a breach. If the child had been allergic to it, there would have been proximal cause, but the child wasn't allergic to it. There was no injury, therefore no malpractice. Bad practice, but not malpractice. So Nurse Practice Act is the first level. Expert witnesses. Now, these are paid experts, usually nurses that have a very similar role as the defendant. So let's say one of you is a new graduate, you're 6 months out of school, and you are accused of malpractice. The plaintiff would bring another nurse approximately 6 months out of school to testify what should have happened. They would not call me to testify as an expert against you because I've been a nurse for 18 years. Unfair. They wouldn't call a nurse practitioner to testify against me, even if the nurse practitioner was a nurse for 18 years, because the nurse practitioner has a different level of education and a different standard. So they're going to look for the same type of nurse to be an expert witness. They're going to look at accreditation. They're going to look at Joint Commission. Or if, like at a nursing home, they're going to go to State Commission. They're going to they're going to look at the accreditation ground rules, staffing levels, educational levels. They can use that to determine if there's a duty. They'll look at resource materials. They may look at the textbooks that are on your floor's resource room. If you put it, let's say you put an IV in incorrectly and something went wrong, they could look at the policy and procedure manual. How are you supposed to do it? Did you follow those rules? And lastly, they could look at accepted standards. They could look at the ANA guidelines or NLN guidelines, the Emergency Nurse Association, ENA guidelines. They're going to look at those groups to see what standards they have. If you don't follow a guideline, whether or not your facility officially accepts it, it could place you at risk. So if the ANA says nurses should do this and your hospital is saying nurses should do this, if they're not the same, you could have a problem. Because while you could defend yourself by saying, my hospital says this, the plaintiff could say yes, but the ANA says this. So that's how they prove a duty existed. As you can tell, it's pretty easy to prove that there's a duty. They'll find a way. Was there a breach? A breach is when you don't do what you're supposed to do. Bottom line. Did you check the 5 rights before giving them medication? Then you won't make a mistake. Did you skip scanning the wristband? That's a breach, and you open yourself up to malpractice. If you look at the PowerPoint slide, you see a picture of a knight there, and I have a quote from Shakespeare, and I'm talking about breaching the castle. The reason why I used that is a breach in that era was when the attackers knocked down part of the wall, a breach in the wall. And the king would command the troops to go into the breach and basically either repel the invaders or plug that breach with their dead bodies. Right? So breach is a big deal. But what happens if that wall collapses on its own and there's no invaders out there? Is that breach a problem? No. Which brings you to, which leads you to the, was there an injury? So if you did something wrong but there's no injury, there isn't malpractice. There's a mistake and you need to correct it, but not malpractice. How can you maintain your defenses? Document everything. Document objectively. Document frequently. You know, I see students and staff, they always document assessments, medications, vital signs. Always. No problem. Have you ever documented patients' emotions or their actions and attitudes? Actions of patients' visitors. Actions that demonstrate compliance or non-compliance. Have you ever documented the patient's interaction with other people in the room? Have you ever quoted a patient? Those will all help protect you should something happen. If you document the patient argued with a family member, or you can think of many examples. You need to document objectively what did the patient say, what did the family member say, but that kind of information could protect you should something come up. They need to prove cause and effect. So let's say the patient is walking with the nurse and the nurse falls. Or I'm sorry, well that'd be bad. But let's say the patient is walking with the nurse and the patient falls. Now, if they're just walking side by side and the patient falls, is the nurse responsible? If the patient was up ad lib, no. If the patient was supposed to have a gait belt on and they didn't have a gait belt, that's a problem. If the patient falls, not wearing a gait belt, but doesn't get hurt, wasn't frightened, and wasn't, anything else, there's no harm, and there's no malpractice. It doesn't mean the nurse didn't make a mistake. It just means the patient cannot sue the nurse for malpractice. Now, remember we talked about civil and criminal. In criminal cases, most penalties result in some sort of sanctions against the person. Time in prison, probation, things of that nature. In civil cases, the penalties are always the same. Money. If the malpractice is proven, the plaintiff may be awarded damages. There's 3 types of damages: general, special, and punitive. General damages are for loss of enjoyment, pain and suffering, and very subjective losses. So when that patient falls and breaks their arm, they can sue you for the pain of the broken arm, for the fear caused by the fall, for their inability to go bowling because of the broken arm. General damages. Special damages are very concrete and measurable. These are damages to compensate for out-of-pocket expenses. So, what did it cost them to get fixed? What did it cost them to be examined, for the surgery, for the lost time on the job? Maybe they had to pay for a home health nurse to come in. Those are all special damages. Very measurable. And then there's punitive. And punitive are punishment damages. These can get big. So, general damages, special damages, and the huge punitive damages. There are a lot of things that can affect the award. Now, special damages, it doesn't matter who was hurt. They're going to look at how much it costs to heal what happened and any other financial losses, and just add that up, boom, special damages. General and punitive damages get very fuzzy and subjective based on who was hurt. So the very old and the very young get very low awards. Why is that? Well, the very old, this is going to sound really terrible, but the very old financially are not worth a lot. They're not working, by very old, we're talking 85, 90-year-old. They're not working, so financially, they're not at risk for losing a lot. And the very young, like the 2-year-old, the 3-year-old, they're not working, and there's no way of calculating what that person would have done. So very old, very young, low awards. A 40-year-old with a family who's working will receive large awards because they can prove how much money they would have earned over a period of time. They can prove how much value they bring to their company and their family and their community. But the other thing that determines awards is the type of injury. Fall down and break your arm, say break your wrist. Cast it, a couple months later it's back to normal. It hurt and it kept you from bowling for a while, but you're not going to have huge damages. What if you fell and due to the fall they had to take your arm off? It's disfiguring. It's permanent. Could be disabling. Those get big. So if you're in a wheelchair or if you're horribly burned or disfigured, those kind of damages can trigger huge general damages and punitive damages. If somebody did something on purpose, a malicious action, those awards get massive. Did you cover it up? If there was a cover-up, those awards will be the largest possible. Because remember, punitive is punishment. And if you did something on purpose and then covered it up, they want to punish you and send a message to everybody else to never do that again. Liability. Well, that's another word for responsibility. And as a nurse, you have personal liability. So do doctors, hospitals, everybody else. Now, here's the thing though. If let's say the patient were hurt, let's say the patient was given the wrong medication. I've seen it happen. No injuries were involved, but I've seen medication errors. So the patient, if they were injured, remember there has to be an injury. If they were injured, the patient could sue the nurse that administered the medication, the pharmacist who dispensed the medication, the pharmacy tech who delivered the medication, the doctor who prescribed the medication, potentially the manufacturer of the medication. If you look in that list, the nurse is pretty small potatoes, right? Well, there's something out there that actually protects the nurse a little bit. It's called respondeat superior. I'm going to spell that out for you so you can write this down. Respondeat superior is R-E-S-P-O-N-D-E-A-T, superior as it sounds. Respondeat superior is Latin for the master is responsible for the acts of the servant. So what that means is if you administer medication based on the doctor's orders, and in your best judgment, that was the correct thing, it wasn't obviously wrong, then while you did administer the incorrect dose, you were acting on your master's actions. And in this case, the master will be responsible for your actions. Now, if the doctor, let's say the doctor orders insulin, and he orders 10 units, and mistakenly writes 100 units of fast acting. Is that a commonplace dose? Would that trigger anybody's questions? It should. So in this case, if you administered that 100 units, the doctor made the mistake, so did you. You should have caught it, or you should have at least questioned it. So that is respondeat superior is when a mistake happens above you and it trickles down to you, and you were acting on good faith. So one of the things is liability as an RN. You'll be responsible for the acts of your LPNs and CNAs. Think about that. You could have an LPN or two and a number of CNAs reporting to you, and you were responsible for everything they do. So what could be involved with that supervisory liability? Well, was the employee trained in what they were doing? If they were, and have previously demonstrated competence, and you supervised them correctly, your liability may be less. Did you follow up? Did you provide correction as needed, and was that correction documented? When you delegate and you follow up and provide feedback, and they make a mistake, when those steps are documented, that helps protect you because you've done your job. You know, people can make mistakes even if their bosses had nothing to do with it. So you can't just blame somebody above you as being the source of your problems. It can be, but that has to be proven. And the other thing is, respondeat superior is involved with, quote, the deep pockets. If you were sued and a doctor was sued for the same thing, who's going to be able to pay more money? The doctor. So generally, nurses will be released because they just aren't going to be able to pay as much. Now, the best defense is the statute of limitations. There's law that defines how long a person has before they can file a lawsuit, and it varies by state to state. There's an assumption of risk. If you remember that patient we said was a cyst of 2 and you got them up by yourself. Well, if that person just had a hip replacement, let's say, and there's a walker by the bed and a call light within reach, and they refuse to turn the call light on, they refuse to use the walker, they get up and walk to the bathroom and they fall, they assume their own risk by not following the guidelines. And also contributory negligence. The patient who goes home with discharge instructions on a low salt diet because they were in the hospital for congestive heart failure, if they go home and they have, let's say a corned beef and cabbage sandwich followed by a bag of potato chips and dip, a lot of salt, and they suddenly go into congestive heart failure, they can't sue the hospital. They went home with the correct instructions. They chose to not follow them. That's called contributory negligence. But documentation is probably your best defense. When you document everything that goes on, step by step, when you document on a regular basis, don't just wait to the end of your shift. Document it as you go along. That is going to be the number one way of protecting yourself. Keep the patient's environment safe. Make sure their call light is within reach. Their walker is within reach. Lights are lit. There's no clutter on the floor. falls are the #1 malpractice risk. Always do more than the minimum assessment level. Always. Make sure you look at everything and document it. Written communication. If somebody gives you a verbal communication, get it in writing as fast as possible. And then incident reports. When somebody falls, do an incident report immediately. See, most people hate doing incident reports because it makes them look bad. And truth be told, it does. Somebody made a mistake. But if you file a report because you did X, and 2 weeks later somebody else does X, because the original cause wasn't addressed, both of you will have protection because you reported it and nothing was done and it happened again. So that's why we report problems, so that we can protect one another. Intentional torts, assault and battery. What's the difference between assault and battery? Do you know? Assault is walking up to somebody and saying, I'm going to punch your lights out. Battery is punching their lights out. Right? Assault is verbal. Battery is when you touch them. Emotional distress, causing fear. Defamation. Libel and slander. What's the difference between libel and slander? Slander is saying that person is a dirty, rotten so-and-so. Libel is posting it on Facebook saying that person is a dirty, rotten so-and-so. Slander, verbal. Libel, written. False imprisonment is most commonly going to be using restraints incorrectly. Sexual harassment, breach of confidentiality, invasion of privacy, torturous interference with contract. That's a crazy one, but let's imagine that you have an agency nurse working with you and you don't like that person. You just don't like them. And so you do things to get them fired. If you do that on purpose, they could actually sue you because you did a torturous interference with their contract. Now, there are criminal acts. Theft is probably the most common. Patient property, facility property, your coworker's property. Practice violations. Ignoring scope of practice could be a criminal act. Misuse of medications. It's unfortunate, but it happens. Either you giving too much, giving not enough, or diverting their medications, stealing narcotics. It happens. There's no getting around it. It does happen. I hope to none of my students. Risk management. There are groups in every organization that manage risk. It could be called quality assurance. It could be called CQM or CQI, which is continuous quality management and continuous quality improvement. It could be peer review. Every facility, every company has their own name for it, but it's all risk management. Risk management looks at not just what's happening in their facility, but what's going on in other places. So if an Aurora hospital will look at other Aurora hospitals and what's happening. They will look at their competitors. If an Aurora facility in one city is having problems and another hospital in the same city is not having problems, they're going to find out why, what's going on. Risk management helps develop standard practices and procedures within the facility. They get reviewed regularly. This also includes employee evaluations and continuing education. The incident report is part of risk management. It should not be a punitive device. It also should not be anonymous. I personally hate getting anonymous incident reports, anonymous complaints, anonymous grievances. For a couple of reasons. First off, I can't go back to anybody and get more information. Because almost always these reports never have enough information. If I don't know who wrote it, I'm stuck. And if I don't have enough information, I can't act. But also, my opinion, it's just my opinion, But if you see something wrong and you don't have the confidence enough to put your name down, my opinion is I don't take it as valid. Now again, that's my opinion only. But I always put my name down because if I see something wrong, I'm willing to stand up for it. I don't like people not putting their names down because sometimes those can be malicious, slanderous, or actually in this case, libelous accusations. So when I put my name down, it's because I'm willing to say yes. I saw that. Now, to be totally honest, did not necessarily make me always the most popular person. But I did what was right. Now what if something happens? Help the person immediately. Apologize. You don't have to say, I'm wrong, but you can say, I'm sorry this happened. Notify the appropriate people as soon as possible. Don't make offers or promises that you might not be able to keep. Don't say, oh, we're not going to charge you for this hospitalization. Because if you say that, that can be held against the hospital. Think about the last time you were at a restaurant that you had a problem with your food. Maybe it was service was slow, or the food is cold, or you got the wrong food. Maybe it's a contaminant in it. How was it handled? How should it have been handled? How would you like it handled? Ideally, you want things fixed immediately. And maybe a gift of some sort as a way of saying, sorry this happened to you. So what you can do as a nurse is help the person, apologize, notify people that need to know as soon as possible. There is malpractice insurance for nurses. It's about $50 a year, so it's not really expensive. As we talked about earlier, 1 in 2,200 nurses need it, so it's very rarely needed. I'll be honest, I don't have it. I am protected through school, and you will always be protected through your facility while you're working there. But the problem is there's that statute of limitations where they have a number of years where they can bring suit. If you quit and then they bring suit, you might not be covered by the hospital's malpractice insurance. So you may want to talk on. Pretty much any nursing magazine, nursing journal, will have an advertisement for malpractice insurance. And like I said, $50 a year, relatively minor. The other thing you can ask when you get hired, who provides malpractice insurance? What's covered? How much is covered? Will it cover them if they're required to appear before the State Board of Nursing? What's the limit of coverage? Is it $1 million total, or is it $1 million per incident? I'll be honest, never asked these questions of anybody. I've been lucky. What happens if you do get to go to court? After you say, oh, fill in the blank, now what? Well, first off, I'm going to tell you right now, most cases never see the inside of a courtroom. That's what lawyers want. They want cases to be settled. It's easier for them. It's faster. You might have to give a deposition. Deposition is where you go in and you testify to what you saw, heard, and did. You might receive a subpoena. I've received one subpoena in my time. It was related to me drawing a blood alcohol test on a person who was arrested for a DUI. So I was called to court. I was supposed to testify. The day before that, they settled all of court. So I never went to court. If you do go to court, dress like it's an interview. Treat it like an interview. Remember, look nice. Act nice. Eye contact. Concise answers. Only what did you do, hear, and say. No opinions, no interpretations. Don't say never, always, I think, maybe, possibly. Okay? Those are weasel words and can be twisted. Take your time before answering. Make sure you understand the question. If you don't, ask them to repeat it in another way. Objective answers. What did you do, hear, and say? You might also go to arbitration or mediation. Arbitration and mediation are outside of the courtroom. They're usually in front of a judge or somebody who's trained. An arbitrator is a person who makes a decision like a judge. A mediator finds common grounds. Frequently, the arbitrator and mediator have binding authority, so they can find a compromise and they can enforce it just like a judge would. But it's faster, it's cheaper. There are legal issues that affect nurses all the time. Obamacare, the Obama healthcare reform is a big one. Third-party reimbursement concerns, improper diagnosis codes, undocumented treatments, improper billing. My wife had surgery, her gallbladder had to come out. They incorrectly coded it, and the insurance company refused to pay it because it was incorrectly coded. If the nurse writes down one wrong thing, it gets coded incorrectly, or the doctor writes it wrong, it gets coded incorrectly. Healthcare delivery issues, telephone triage and telehealth. How would you like to work on the phone telling people what to do based on what they tell you? That's high risk because you don't see the person. You only know what they tell you. Rapid discharge to lower levels of care. How long do people stay in the hospitals anymore? Not long. And they go from hospitals to nursing homes or hospitals or to rehab facilities fast. It can be an issue. It's too fast. HMOs and PPOs, we'll talk about those in Learning Plan 8, I believe. Same with utilization review. Other issues, pro-life, pro-choice, fetal rights, human experimentation and research, stem cell research, living will, advanced directives, DNR, partial DNR, right to die, assisted suicide, mandatory organ harvest, mandatory vaccinations. There's a lot of stuff out there. It can all affect nurses somehow. You need to have an idea of where you stand on these to help you find where you best fit. So, guess what? You survived the legal lecture. We're done. That's it. So, I'm going to end this now. I will quickly do one more video. We'll talk about the discussion questions for this week. And then you're off to have some fun. Talk to you later.